My name is Richard Heideman, and I have the privilege of serving as the chairman of the JNS International Policy Summit. We want to thank each of you for your participation. I want to pay tribute to Alex Trayman, the CEO and Jerusalem Bureau Chief of Jewish News Syndicate, for conceiving of this conference, now a summit. I want to thank each of our esteemed speakers for joining us as forum speakers. Each one has in CLE seminars, in courtrooms, to the press, each one has delivered hours of wisdom and are capable of doing so here today. But in the hour and 5 minutes we have for this particular panel, we've asked each to keep their remarks pointed and direct. In this legal affairs forum, you know, everything begins somewhere. And I can tell you from personal experience that as it relates to legal affairs, there is, in my view, a dean in the field. His name is Steve Perles. He serves as an adjunct professor. But more than that, Steve is not an academic. He is a designer of litigation who, long before it was popular, conceived of the need to bring cases on behalf of victims of terror, and who conceived of the need to see to it that legislation to augment or to supplement or to replace decisions of courts would be brought forth. For disclosure purposes, Steve and I shared offices together for more than a decade. We've been friends for multiple decades. We work on cases together. We have joint interests in those cases. I want to take this opportunity to ask you to welcome for our overview remarks Stephen R. Perles.
Richard, can you hear me out there?
Yes.
Yeah. Richard, you know, continuing with disclosures, where's Dov Gold? He's one of our case partners, and he's out there in the audience. Thank you very much. I'm flattered that you actually came in. I much appreciated, my friend. Thank you. You know, Richard has asked me to give a short overview, and I must tell you, Richard, I went off to teach a 3-day seminar at the University of Michigan when my now grown and married daughter was a teenager, and I said to her, you know, what am I going to talk about for 3 days? And she said, Dad, you're a law professor. You can talk about anything forever and ever and ever. So when I reach my limit, cut me off, please, or I will talk forever and ever and ever. Thank you. I'd like to talk about the legal regime that we've built over the last 40 years in the United States by focusing on one word.
Speak into that microphone, please.
I will, Richard. Thank you. By focusing on one word, deterrence. Okay. And I want to contrast that singular word with the notion of compensation. For those of you in the room who have suffered losses, and all of our clients suffer losses, we manage about a $30 billion portfolio in the terror victim space, and we have successfully separated material supporters of terrorist attacks where U.S. nationals have been killed or non-U.S. nationals killed in service to the United States, such as non-U.S. citizens who are employees of the Department of State posted at embassies around the world when terrorist attacks occur. And we've taken about $4 billion away from the material supporters of those attacks for their U.S. victims. But I'd like to contrast deterrence with compensation, and to start to say my firm is not in the compensation business. We're in the deterrence business. And when you are in the deterrence business, winning judgments is not enough. Okay, winning a judgment is meaningless. The real art form, what makes the litigation so robust, is the enforcement phase. 90% of what anybody does in this field who believes in the use of lawfare as a deterrent to would-be future material supporters of terrorist attacks has to focus on enforcement. Richard asked me to give a brief overview. We actually started our first project in 1986. It was litigation, I'll say, left over from the Second World War. The Federal Republic of Germany, for reasons no one really understands, declined to make U.S. nationals who had been in concentration camps, and I'm talking about people who were U.S. passport holders while they were in the camps. These are people who were in Europe at the outbreak, U.S. nationals who were in Europe at the outbreak of the Second World War and simply in the wrong place in the wrong time and did not get returned in the civilian prisoner exchange. Germany would not compensate those people the way they compensated their own nationals. We fixed that. And for those who spent time in concentration camps while they were U.S. passport holders, the money was meaningless. It wasn't about compensation for them. It was about deterrence and a recognition of the wrong so that it never happens again to citizens of the United States. The second case that we brought originated in Israel. It's styled Flato versus the Islamic Republic of Iran. The Islamic Republic of Iran initiated a bus bombing campaign in Israel in direct response to what at the time was a very successful peace initiative that President Clinton had initiated. Elisa Flato was the first United States citizen killed in that bus bombing. And we received enormous pushback from the Department of State, not when we were litigating the underlying material claim, but when we went out to enforce the judgment. We received so much pushback that the Department of Justice offered to pay Steve Flato the entirety of his compensatory damages plus post-judgment interest from the United States Judgment Fund. That's with U.S. taxpayer dollars. And Steve, to his credit, it's part of what in my view makes him an American national hero, turned the Justice Department down. He insisted that we would enforce his judgment only against Iranian assets. And that heroic act on his, not my part, I didn't do that. That was Steve Flato. But that heroic act—
1 minute, please, Steve.
Sorry?
One more minute.
Thank you. Resulted in President Clinton endorsing legislation which allowed us to liquidate certain blocked Iranian weapons funds that had been left over from the days of the Shah. And finally, I'd like to turn to two more cases very quickly. Peterson versus the Islamic Republic of Iran, where in a very unusual set of circumstances, the State Department, the Justice Department actually endorsed what we were doing through two administrations, Bush and Obama, and we were able to separate the Iranians from $1.9 billion that they had illegally laundered into the United States to help raise money, which they need to raise dollars to fund terrorism and to fund their illicit nuclear program. And finally, I'd like very briefly to talk about a case that Dov and Richard and I share in New York against Binance. It is a pending case. We are winning. Dov's firm, Side & Law, is our local counsel in New York. We have survived Binance's motion to dismiss, but our intention in that case is to win a judgment against a Chinese crypto company, Binance, that used crypto to launder money to Hamas, and at the end of the day, to enter and enforce a multi-billion-dollar judgment, sending a clear message of deterrence to any would-be money launderers, particularly people in the crypto world where one has a lot of illicit and illegal activities that go on. If you launder money for a foreign terrorist organization and that activity results in the death or injury of a U.S. national, you will be hunted to the end in a multi-billion-dollar proceeding.
Thank you, Steve.
Thank you, Richard.
Steve and I jointly and proudly represent, but sadly represent, the family of Malky Roth, Oliver Shalom. Her father, Arnold Roth, has been battling for what I call justice and accountability ever since she was so tragically and heinously murdered in the Sbarro Pizza bombing here in Jerusalem. Arnold, please share your thoughts. Microphone.
Thank you, Richard. I've practiced law myself for some 40 years, and I find myself at the worst stage in my life. In other words, the stage where I needed everything that I had learned through all of that time in a legal process that is spectacularly paralyzed. This JNS summit comes at a moment demanding moral clarity and courageous leadership from the United States. Today, I focus here on a case that encapsulates those issues. Ahlam Tamimi, the Jordanian terrorist who orchestrated the 2001 Sbarro Pizzeria atrocity in Jerusalem, murdering 16 innocents, including 3 Americans. The Jordan Tamimi case exposes a troubling truth. Jordan, a US ally, has failed on 2 fronts, refusing to condemn Tamimi's terrorism and violating a cornerstone treaty made with the United States under President Clinton. This injustice has festered in silence for years. It's time for the US to lead with principle and hold treaty partners accountable. Tamimi is no repentant fugitive. She scouted Jerusalem for a target rich in families and children, settling on a crowded pizzeria during school vacation. She accompanied the human bomb to the site, then rushed back to Ramallah to present the evening television news. She was a newsreader. Since then, she's lived freely in Jordan, celebrated as a hero. She hosted her own television show, addressed rallies, appeared on social media, bragging all the while about the lives she ended, including the life of my daughter Malky, an American citizen whose memory demands justice. In 2017, the US Department of Justice charged Tamimi with terrorism, actually 4 years earlier, but those charges were kept secret, which is at the very heart of the nightmare that has overwhelmed my family, and added her to the FBI's most wanted terrorists list, offering a $5 million reward for her capture that no one has so far claimed, even though she has not been in hiding for a single hour. Jordan, bound by a 1995 extradition treaty, a bilateral treaty with the United States, refuses to hand her over. Jordan's courts claim the treaty is invalid, a technical argument contradicted by facts, by documents, and disputed by the United States. Meanwhile, Jordan's leaders remain silent, unwilling to condemn, even the smallest way, Tamimi's crimes. This silence isn't neutrality, it's complicity. Jordan accepts billions in US aid, pledges cooperation against terrorism, and even outlawed the Muslim Brotherhood last week. Muslim Brotherhood is the political point on the spectrum with which Tamimi is closely aligned. Yet Jordan continues to harbor the woman who is America's most wanted female fugitive, prioritizing political convenience over principle. This makes a mockery of justice and erodes trust in international law. The United States cannot afford ambiguity on terrorism. After 9/11, Washington demanded that allies stand with the United States or step aside. It's time to apply that same clarity here. My family and the families of other victims deserve more than sympathy, which we get in large and rather thin doses. We deserve action. Treaties are not guidelines. They are solemn promises, contracts. Jordan has extradited other terrorists under this same treaty that it today calls invalid. Why is Tamimi different? Today I announce that nearly 27,000 people have signed a petition urging the United States Secretary of State to press Jordan to extradite Tamimi. From this podium, I call on you, America's storytellers, thought leaders, and conscience, to bring this painful affair into the light. The White House, Congress, State Department have tools at their disposal: diplomatic pressure, economic incentives, even aid conditions. They must use them. And the media must challenge them to act. Terrorism thrives when nations waver. By insisting on Tamimi's extradition, America would reaffirm that terrorists cannot escape accountability. When justice is shoved aside, the foundations of civilized society are undermined, but it's not too late. We yearn for leadership that is principled, determined, and unwavering, and for media reportage that respects the doctrine of neither fear nor favor. Justice for my Malki and the other innocents must matter more than the savages who took their lives. Let us unite to make that happen.
Thank you. Thank you, Arnold. Next, Lori Lowenthal Marcus.
I have a very different story from what we've heard so far. My battle of the Deborah Project, is on American campuses. And we're fighting what would be a comic book version of, the survivors of the Shoah or victims of terrorism. But what we're fighting is a version that isn't a cartoon, it's reality, and it's dangerous, and it is anti-Semitism, which has exploded not only on the college campuses in America, but in K-12 schools, in the public schools all across the United States. And these children are being marinated in Jew hatred coming from the front of the room in pre-K all the way up through 12th grade. We deal with the colleges and universities as well, but you've seen those stories. They're great visuals when you watch the encampments and the protests. The visuals aren't great in K-12, but the alarm is huge because these kids are going to grow up believing that the Jewish state and Jews are evil and deserve everything they get. And it won't be just from reading the New York Times and CNN, watching CNN and the BBC or Al Jazeera. It will be because they learned it when they were little kids from the authority figures. So that's a challenge, and it's a serious one, even though we're dealing with, or maybe because we're dealing with very young people who will pose a presence of a hate wave to us, the Jews, the Jewish people, for a very long time. There is now litigation that's happening. We are bringing cases. There are a few other public interest law firms and institutions that are bringing lawsuits, but it's difficult to get Americans, including American Jews, to understand that Jews have civil rights as well. We are entitled to the same freedoms every other group has asserted and been given. And so when we bring court cases now, we're filing complaints like everyone here in this panel does, and like everyone else, we're also filing information in the court of public opinion. And we are trying to educate with our legal documents and with articles following up what's happening and discussing with the media why this is so important. And it plays out in particular in the little interstices, the ones where swastikas we know are bad, but talking about, and this was on a college campus, the fact that Israel is using COVID as a weapon against the Palestinians. That was something that was permitted to be taught, given as an event, as stated in the affirmative, not question mark, not might be, what if. No, it is. Israel is using COVID. And the president of that college, when confronted, said, oh, well, that's not anti-Semitic. That's about Israel. That has nothing to do with Judaism. So that's, there are so many different parts of it that all of us have to be fighting. We have to make it clear that love of the Jewish state and belief in its existence and right to exist as a Jewish state, that is Zionism, when you deny that to the Jewish people, that's anti-Semitism. And for heaven's sake, there are so many Jews who argue with us about this. So one of the policy recommendations that I want to offer is the insistence that all of us who know the truth use the word Zionism and anti-Zionism to mean exactly what we know it means, because they don't know what it means. They are able to ignore the reality. They don't know our history. They don't want to know our history. And when I say they, sometimes I mean us. I have dealt with parents all across the United States, but one in particular in California, I remember saying, you know that series of maps that show disappearing Palestine? It's been a trope for a long time. It shows
30 seconds.
It shows how, it all used to be called Palestine, and now there's only a little bit that's Palestine. And this parent said, well, I know there's a problem with that, but it's very complex. Can someone explain it to me? Oh my God, are you kidding? So we have a big battle on many fronts, and I urge everyone to please engage in this battle, assert Zionism, assert the civil rights of Jews, support everyone on this panel who is fighting for these rights, and thank you.
Thank you very much. Maurice Hirsch.
Thank you very much, Richard. I would actually like to try and address the whole situation of dealing with terrorism and the end results, but from the start. As my background as the head of the prosecution for Judea and Samaria, I think there are a number of things that need to be implemented into Israel's legal system that we can then promote on to fighting terrorism. Firstly, we need to change the manner in which sentences are handed down to terrorists. Terrorism is really a disease which has no cure. It is an ideological disease which cannot be dealt with in the same manner that we deal with regular terrorism, with regular crime. When you deal with regular crime, you start at the lowest sentence and you gradually move upwards. With terrorism, you shouldn't be doing that. You should be starting at the maximum sentence and then moving downwards should there be extenuating circumstances that could possibly legitimize the actions, or at least in some way bring down the severity of those actions. If we start very much with the stone throwers, those terrorists who are throwing only Molotov cocktails at the Jews driving on the roads, and we put them into prison for a much longer periods of time. Just to give you an idea, the average stone thrower, whilst he may be causing mortal danger, goes into prison for about 6 months. If you throw a Molotov cocktail, you go into prison maybe for 8 to 12 months. This is not a situation that deters anybody. And then you have, obviously, on top of that, the whole system which really feeds into that commission of terrorism. It's the Palestinian Authority's pay-for-slay program. We all know about it. We've all heard about it. The Palestinian Authority rewards every single terrorist who acts against Israel. This has now become a doctrine upon which victims are granted compensation because of this practice. It gives rise to their responsibility. But what would happen if we actually changed that system from its base? If we didn't allow the Palestinian Authority to in any way pay salaries to terrorists? Maybe they wouldn't get involved in terrorism. Take into account, everyone, that Israel provides 66% of the budget of the Palestinian Authority. That means that of every 100 shekel that the Palestinian Authority pays to the murderers of Jews, Israel contributed 66 shekel. That's a huge amount of money. We are literally paying the people that murdered our relatives, that murdered our friends, that murdered our children and our loved ones. And this is something which needs to be changed. There's so much more that can be done. There's reactive law. It's called the freeze law that was passed in Israel, which penalizes the Palestinian Authority for paying the salaries. But if we went to the terrorists themselves, they have a whole situation where they tell the terrorists, we're going to pay your salary on X day. They pay those salaries via ATMs. Imagine what would happen if on one night, the Israel Defense Forces went to every single one of those ATMs and confiscated the 50 million shekel a month that they pay to the terrorists. In one night, you'd have a massive attack on the payment of terrorism. The terrorists wouldn't get their money, and we would see something that would change. We've actually investigated the whole system. We brought about really the closure of 35,000 bank accounts. They moved to the system. It's standalone systems. It won't affect the entire banking system. It's an easily implemented solution, which unfortunately hasn't taken hold. This carries on into every single field where I can say from the head of the prosecution isn't quick to release materials to lawyers then suing the terrorists. And that is something which is a huge mistake. I would hope that in some way, I assume that the lawyers on the panel remember the report of Danny Naveh. This was a ministerial report that was written about the terrorism initiated by the Palestinian Authority in September 2000. I would very much hope that Israel has learned the lesson from that, and that now, after 18 months of fighting in Gaza, there is going to be a similar report detailing every Iranian connection to the fighting, to the massacre, that can be used on a wide-scale basis against or for the benefit of every single one of the now 2,000 victims of the October 7 massacre. Now, the October 7 massacre, and here maybe a tip for my colleagues on the panel, it's not only Hamas. And one of the really integral players in this situation that has gone almost scot-free is Hezbollah. Hezbollah, we have to remember, a day after the massacre, joined the fight, caused the evacuation of 120,000 Israelis from the north. Binance was integrally connected to that. Binance, if you follow the site of the Ministry of Defense, the Ministry of Defense has since seized funds from Binance Binance, for the audience who don't know, Binance just a few months before the October 7 massacre in July 2023 came to a plea bargain. The head of Binance paid a $4.5 billion fine for its financing of terror. The case should be, to a great extent, a slam dunk, and that needs to be done. One last point, which has nothing to do with anything else, but is more to do with Israel standing up for its own legal rights. In the same way as Israel still funds the Pay for Slay program, Israel also funds the PLO, PA activity in the International Court, Criminal Court in The Hague. That same court that's now issuing arrest warrants against the Prime Minister, against the former Minister of Defense. Don't be fooled by the joke decision that they released a few days ago. It says that the lower court really mishandled the decision, mishandled the arguments, and they're sending it back to the lower courts. But they didn't cancel the actual outcome of that, which was the issuing of the arrest warrants. What type of a decision is that? It's a political decision rather than a legal decision. And on that front too, Israel must remember, we are funding the PLO, the PA activities there, and that should also come to an end.
Thank you very much, Maurice. From UK Lawyers for Israel, Jonathan Turner.
So I have three recommendations that I'd like to put forward. Firstly, a more aggressive legal policy by Israel in international bodies. Secondly, within national, subnational, and regional jurisdictions, I would like to see more use of laws and legal skills to support Israel by persuasion and not just through litigation. And thirdly, I'd like to see the development of more and stronger associations of lawyers supporting Israel in different countries around the world. And let me explain these briefly in turn. Firstly, the more aggressive legal policy by Israel in international bodies. I think this should be in both offensive and defensive ways, in both substantive and procedural issues, and in both tribunals and in the court of public opinion. Let me explain further. Offensive, by that I mean that Israel should pursue claims against other states and parties, for example, against Iran for conspiracy and incitement to genocide, but also defensive. No claim against Israel should be left undefended. There may be some cases or tribunals where it's better for the state of Israel not to engage itself in order to avoid giving the process more credibility, but where that is the position, we should ensure that Israel's defenses are fully presented by allied states or NGOs or both. Substantive claims should be made and defended, and we shouldn't just wait to be attacked as we currently are, but also procedurally. All legitimate procedural points should be taken. If judges are apparently biased, and many of them are, they should be asked to stand down. Now, these objections may well be rejected, but that's not really the point. And here we come to the third aspect, the court of public opinion, and the importance of combining a strong legal strategy with a strong communication strategy. Because in general, international tribunals do not have power to enforce their decisions except by persuading people, politicians, and leaders to act on them. So if a judge is biased, we should challenge this, even if we don't actually expect that to result in them standing down, and then do all we can to publicize the objections, to diminish the confidence placed by the public and politicians in any biased judgment that ensues. Then the second recommendation, more use of laws and legal skills to support Israel by persuasion in national, subnational, and regional jurisdictions. There is an important role for litigation in support of Israel and against its enemies, as various colleagues here have mentioned, but it's not the only way in which laws and legal skills can be deployed in support of Israel and against the activities of our enemies. A great deal can be done by correspondence, persuading people to comply with the law or to enforce the law. This is normally much less expensive and quicker than litigation, and there is less risk of it being occasionally counterproductive. Our organization, UK Lawyers for Israel, used to get dozens and now get hundreds of results every year. One of the challenges is that it can be more difficult to present this kind of work to supporters. If you have only a 5-minute pitch with a busy person, you can say something about one big case and how important it is, but it's more difficult to get across the range of work that you do in a year on hundreds of matters. So I think this type of work tends to be under-resourced and should be better resourced. And this brings me to the third recommendation, the development of more and stronger associations of lawyers supporting Israel in different countries around the world, so that lawyers have a correct understanding of facts and legal issues relating to Israel, who will therefore encourage the anti-Israel, able to counter the anti-Israel misinformation and distortions. We've developed UK Lawyers from Israel from a small group of volunteers in 2011 to a network of thousands of lawyers and several remunerated staff. My colleagues produce work of the highest quality. We've built up considerable expertise in tackling a wide variety of anti-Israel activities. And I'd like to see more of this going on around the world. And we've also explained the facts and legal issues in the media, debates, talks, webinars, analyses and evidence, most notably through my brilliant colleague, Natasha Hausdorff. I'm often asked these days to develop more Natasha Hausdorffs. Now, this is not easy because she is a unicorn, but we do hope that more and more people will be inspired by what we do and other similar organizations do and what we achieve to join in this important work.
Thank you so very Jonathan, thank you so very much. And we now go to the infamous Natasha Hausdorff.
Well, what a privilege and a pleasure it is to share this panel with so many heroes of mine and people that I feel very honored to also call dear friends. It is very special to be in this company, both up here and familiar faces that I'm recognizing out there. Thank you very much for the kind words. There is actually another one of me. I have a baby sister who is ready and raring to go. But unfortunately, she's still very much at the beginning of her career, so it might take a little while before she's able to be quite as outspoken. But the two asks that I wish to make to you in the very few minutes that I have is in relation to being more outspoken. I would like to encourage you all, as I have been inspired by some of my fellow panelists, to exercise more tachlis in your own advocacy, especially on legal issues. And the reason I say that is I fundamentally believe that we as civil society have a great deal more to contribute, not least because we can say more than even the State of Israel can, for various political, diplomatic reasons, which I'm sure we can all appreciate. There is a deficiency of Israel officially demanding its legal rights and demanding an equal application of international law to the Jewish state. That is our space. And in doing so, we're calling not just for international law to be properly upheld with respect to the Jews, but we're also calling for international law to be properly respected, international rule of law, to combat the weaponization of international law in international courts and tribunals, and the erosion of legal concepts, the abuse of legal terminology, occupation, ethnic cleansing, colonialism, apartheid, genocide, presents a major threat to the international rule of law and to Western civilization as a whole. And that should be our call to arms. No matter what the officials of the State of Israel say, when we look to the status of the territory, and when we demand the equal application of international law and the customary rule of uti possidetis juris, and I'm particularly thrilled that Professor Eugene Kontorovich and Professor Avi Bell, who wrote the book, or at least the article, I hope the book is coming, the Arizona Law Review article that called this out, the decades of double standards and the absence of the proper application of international law in this respect. And to see the Vice President, former Vice President of the International Court of Justice, Julia Sebutinde, referencing this rule referencing the absence of proper legal analysis by the majority in the advisory opinion last year, indicates significant progress, indicates the voice of civil society can be an extremely powerful one. And now we know that the academy, the legal academy, has been taken over. We know that international courts and tribunals have been taken over. But we have a powerful voice to be calling out these falsehoods and this abuse of international law, as I say, not just on behalf of the State of Israel, but also Western civilization around the world. And this brings me to my second plea. If the first is to be more tachlis, the second is to coordinate and cooperate. Because we are few in number, but we are powerful when we work together. And again, with reference to incredible colleagues, Jonathan Turner, Yifa Segel, Eugene, Avi, the coordination on developing legal argument in applying international law to the developments that we're seeing in international courts and tribunals, and critically in making legal submissions. And perhaps I'll end briefly with reference to the International Criminal Court, because our efforts collectively to call out the ICC, which ceased to be a court when jurisdiction was thrown out of the window. Ladies and gentlemen, what differentiates legal institutions from political ones is jurisdiction. The ICC has no jurisdiction over Israel. It has no jurisdiction over a so-called state of Palestine, not least because that entity doesn't exist as a state. But the Palestinian Authority is in no way able to delegate to the court jurisdiction that it does not have. The founding document of the PA, the Oslo Accords, made it clear that there would be no criminal jurisdiction over Israelis. So the fact that jurisdiction has been thrown out of the window, the fact that this court is in breach of its own rules, the rule of complementarity, and the timing of its warrants application was very telling. But I think even more significantly, the fact that these warrants were based entirely on false information, and I advocate very strongly to you a letter and submissions that UK lawyers for Israel have made to the court, to the prosecutor, which demonstrated that every phrase of every sentence of the prosecutor's application for warrants was false. That is your ammunition. Use it. Call out these falsehoods, these modern blood libels, wherever you can. Please come to the UK LFI website, utilize the resources that all of the incredible lawyers that Jonathan leads and referenced have created for you, and collectively, coordinating and cooperating, let's make sure the rule of law is upheld with respect to the Jewish state. Thank you.
Thank you, Natasha. Avi Bell.
Am I alive? Yeah. Okay. Thank you. It's a great honor to be with all these friends and colleagues. I will try not to sound like what I fear it's going to sound like. I want to put a slightly different perspective on some of the things that have just been said, and I hope it's complementary, and it should be understood that way. I want to draw a sharp line between two different kinds of functions of the law. There's law that's intended to vindicate rights. Right? This, what Steve is talking about, what Steve Perles was talking about, is utilizing the legal tools that we have to protect victims of terrorism in order to get them compensation and to deter the funders of terrorism in the future. And this is a fairly straightforward function. It's extremely important. It's not the function that I deal with for the most part. Right? I mostly function in academia and in international institutions. The way they deal with law has very little to do, generally, with the vindication of rights. It has to do with law as a tool for advancing narratives. And the way one has to deal with that function is entirely different from the way one deals with law as a means of vindicating rights. Now, I also have to say one has to distinguish between different kinds of institutions in this world. So where Steve Perles does his work is, for the most part, in US courtrooms, which I can't say that they're perfect, but for the most part, one could say that they play it more or less straight. And it is possible to make legal arguments, to convince judges, and to win on the merits. It is not possible to do these things in the ICC or the ICJ or in UN committees or in most international institutions. It's certainly not possible to do so in academia. So when you're thinking about how to deal with these institutions, it's not simply that you can't think of the main function as utilizing law to vindicate rights. It's also you couldn't possibly win if you tried. Right? The institutions are stacked in advance. Now, when one comes up with one's strategy for dealing with how does one utilize the law in the ICC or the ICJ, or frankly in academia, in political rhetoric, one has to think about this entirely differently. Right? One has to think about what are the points that I want to get across to the public, despite the fact that this institution is going to be battling me all the way. And what are the ways in which I can use it to muddy the waters for them? Now, I'll just give a brief example. One of the things that anti-Israel advocates do is that they try to launder fictional legal accounts of matters, that Israel is committing XYZ horrible crime through an official document, right? It's a UN report on such and such. It is a ruling of the ICC on ABC. And by putting it in this official document, they're giving it weight in real institutions thereafter. So I can take the document from the UN committee, and now I can go to trade regulators in Canada and say, well, you can see that it is unlawful, therefore, to deal with Israeli products in a certain way. Or you can go to tax enforcers, tax regulators, even in the United States and certain states, and say, what you can see is that the following Israeli organization should not be recognized as operating properly under US law because it is unlawful in certain ways. Now, they're using this, right, to launder fictional accounts. Now, we should be able to use it to launder actual, factual accounts. This is more easily done in academia than it is done in international institutions. There is no way that we can co-opt the ICC or the ICJ or the UN or any of the subordinate bodies of the UN. But academia is more diffuse. It is possible to find certain people, certain departments in academic institutions that will put out a different narrative. And it's worth thinking about how to do that. Now, you can't do this willy-nilly, but it is possible to co-opt in certain ways. The other thing to think about is that there has to be some way of integrating narrative strategies. So inherently, when one was vindicating one's rights in a reasonable court, like Steve Perles is doing, then that advances a narrative that is useful to us. But when we take arguments to the ICC, to the ICJ, to the other places where the deck is stacked, we have to think about what is the narrative strategy that we are serving. It may be worth not engaging in certain fora, in certain places, because we are advancing their narrative. Telling people that I am not an axe murderer is not a good PR line. Okay? And maybe that's not the thing that I want to spend my time doing.
Thank you, Avi. Eugene Kantarovich.
Is the mic on? It's on? Okay. It's a great pleasure to be here with such distinguished and accomplished colleagues. And I think in my comments, what I want to discuss is how I wish we didn't have to be so distinguished and accomplished. And I'm very much of a free market guy. But there's certain things that are best done by governments. And one of those is advocating for their own legal rights. And I want to present a series of examples where the State of Israel has, let's say, been lagging in adopting legal arguments that advance its own interests and happen to be true. Just last week on Friday, the United States Justice Department announced that UNRWA, the United Nations Relief Works Association, is not entitled to the immunity enjoyed by international organizations because it is not a subsidiary body of the General Assembly, and indeed, they even suggested, because it may have been illegally and improperly ultra vires created by the General Assembly in the first place, and for other reasons. That's a fantastic result, which will allow victims of terror to sue UNRWA in United States courts. Now, the government of Israel has in fact attempted to repeal the immunity of UNRWA in legislation passed a few months ago, which purported to remove the immunity of UNRWA. However, it is the position of the government's legal advisors that you cannot repeal the legal immunity of UNRWA because it just has total and absolute immunity, which no one can do anything about. They didn't say that this is a possible position, or a position that maybe UNRWA could adopt in potential litigation. They said it's their view, and indeed the only reasonable view. Natasha mentioned that for the very first time in Israel's history, a judge on an international tribunal, of course in dissent, endorsed the uti potestatis theory of Israel's borders, which is indeed the theory of every country, every new country's borders. This is a fantastic development, but it certainly has not been facilitated or promoted by the government of Israel, which lags behind the judges of the International Court of Justice in articulating this argument. By the way, if you ask them one reason they don't articulate this argument, they say, it's too late, who could we ever convince? So if just private actors, right, could make arguments that are adopted by one ICJ judge, imagine what would happen if this had actually been the position of the State of Israel for decades. We say that the International Criminal Court is an illegitimate court, a court that's not really a court, a political tribunal that acts based on women politics. When the Attorney General of the State of Israel says that Israel must assemble a commission of inquiry to analyze its conduct in the Gaza war so as to assuage the ICJ's concerns and satisfy the complementarity principle, she is saying that the ICJ is in fact a rule-bound organization that is functioning as a court, and if we check the legal boxes, everything will be okay. In this case, she's also saying this to advance her own institutional power. In all of these cases, the position of the government of Israel sets back advocacy for the government of Israel. The government of Israel, for example, has not publicly explained why it is appropriate and why in fact necessary under international law to allow people in Gaza to seek refuge from the conflict. We had to wait for President Trump to endorse that, but of course without a detailed legal explanation. One could go on much more. One final general kind of example. Normally, when a lawyer has a client who's accused of serious wrongdoing, if the client, even if, let's say he just got hired by the client, the first thing he's going to do is get out and say, my client did no wrong and will be fully vindicated. Often, representatives of the Israeli government, when accused of, let's say, war crimes in Gaza, say, we're looking to see if we did something bad. We don't know all the facts yet. Let us check and get back to you. That's not standard messaging in serious criminal matters. So my plea to you, my plea to the government of Israel would be to get on the cutting edge of this rather than be dragged along.
Eugene, thank you. Ambassador Alan Baker.
Thank you very much, Richard. The advantage of coming towards the end of such a distinguished panel of jurists is that I can take a more macro view rather than a micro view. And I think this was my purpose. And therefore I thank you for putting me where you put me. Look, the legal affairs forum, the term legal affairs refers to both internal legal issues and international legal issues. And in my daily work, I'm involved in hundreds and even thousands of international law issues dealing with any sphere, whether it's military law, whether it's immunities, whether it's human rights law, whether it's United Nations, whether it's EU and anything else. And there's a large number of practitioners who write, including on this panel, who write very distinguished legal articles in various journals and who give lectures. And to a large extent, a lot of this information is treated independently and isn't coordinated. And what I want to try and propose to this forum, and there have been various legal fora that have been established and that have failed to coordinate a legal action. And I was involved in one or two of these. I proffer the Jerusalem Center for Foreign and Security Affairs together with the JNS as a forum for coordinating the actions of international lawyers, coordinating the issues of international law that we have to deal with, and ensuring that these are dealt with in a professional manner without political intrusion or bringing political viewpoints that sometimes direct various international lawyers in what they write. We have to maintain our professional independence and professional capability, and this must be done in an organized manner. And therefore, I'm suggesting that the Jerusalem Center can serve together with JNS as a coordinating body that will bring together both the issues and those who are able to deal with them with recommendations on how to deal with them. That's one point. The second point that I want to make is another international legal point, which is the United Nations. Now, I say this after having worked within the legal office of the United Nations for 4 years as a UN lawyer, but also as president of the Israeli branch of the World Federation of United Nations Associations. So I got several hats here. Now, look, the United Nations, based on its own charter, was intended to be a very fair organization, and it guarantees, for instance, sovereign equality to every state member. But the United Nations has become ultra-vires its own charter. It's not functioning, it's been hijacked, it's not capable of functioning. 193 states dictate to the UN, which was originally 50-odd states, allied states. The UN can no longer function, and therefore the UN needs to either be dissolved or be changed. Now, you might say that, well, he's naive. But today, when we have a US administration, and when the US pays 25% of the UN budget, if the US were to pull its budget, the UN would dissolve. And there are other organizations of democratic states that can come to function instead of the UN. So I think that we should now use the time that we have to try and garner the United States, but also the international community, to come along and say, look, this organization, which we all placed so many hopes in, is no longer functioning. It's not doing what it's supposed to do. Read the Charter. The Charter says very noble things, but the UN is undermining every one of the principles of the Charter, especially with regard to Israel. So what I'm recommending is, in addition to my previous recommendation, that we take very seriously the proposal that we ask the United States to consider reviewing its membership fees in the organization, and this would in itself bring about a chain reaction that could possibly bring about a change in the way that the world organization is functioning. I may be naive, but I think now is the chance to do this. Thank you.
Thank you. To summarize for us, our Vice Chair, Yifa Siegel.
Okay, hi everyone. I want to start by first saying I want to thank Richard Heideman for his amazing leadership, also friendship, but amazing leadership for so many years in this area, fighting for Israel, fighting in the legal realms, fighting in every way that he can. So thank you also for organizing this conference and getting all of us together. It's great to see everybody. So I was thinking about what I can possibly say in a few minutes about this issue that we can talk for hours and days and maybe years. And I just want to offer like a quick summary of how I see things currently. So, you know, the world is always changing and there are always new opportunities and challenges on the international stage, but also on domestic fronts. So I just wanted to offer a few thoughts on what we can do, what we can focus on. I mean, I think we all know the challenges. We see governments that are rising, that are supporting anti-Israel causes and narratives. And I know that my colleagues here have been fighting more severely to help Jews in the diaspora, fight on college campuses and all these fronts that are getting more and more difficult, fight the terror funding. But I want to focus a little bit on opportunities. So let's talk about Israel first. So we are at war. We have been at war for a year and a half. I think we haven't done it. There is a lot more to do in influencing the, first of all, legislation that must be passed here in Israel, but also enforcement. So I once wrote a review about laws that exist in Israel that are not properly enforced, because a lot of ministers and Knesset members come to you, also parliament members from around the world, and say, suggest some kind of a new legislation. And I say, first, how about we enforce existing legislation? Because there are amazing laws in the books, like Ellen said about the UN Charter. It's a beautiful text. No one knows what it is, no one cares about it, but it's beautiful. So let's first of all focus on enforcing existing legislation. So we, like Eugene said, there was a legislation passed regarding UNRWA. It hasn't been properly enforced. There's a lot to do here. We have to start at home. UNRWA can function here, can continue to teach children in East Jerusalem, can continue to supply humanitarian aid and have it been the channel to sustain terrorist organizations like Hamas, but all the others as well. So that's one idea. I think that we should do something about Maurice, to your point about terrorism, I think that we have to think creatively. I suggested in the past, I want to continue suggesting now in this new Knesset to create an alternative of a very heavy fine, not just jail or go home and probation, but also a significant fine. If you're a 16-year-old throwing rocks at moving cars in Judea and Samaria, then for example, 20,000 shekels would definitely get your father to be the one to prevent you from throwing stones next time. You know, I can go on. I want to talk about the U.S. for a few seconds. I don't have a lot of time, but we've seen this administration do things that, you know, we've been trying to do for years. I don't know if you've seen the declaration coming out of the New Israel Fund, you know, regarding the new Trump policy. They're now warning all these organizations that they are the fiscal sponsor for not to be active against Israel in the ICC front. You know, to scale down anti-Semitism. So, you know, we've been trying to get them to, you know, to care. They don't care about the issue, obviously, but having their 501c3 status revoked, that they care about, okay? So we can be very, very active about pointing out all these organizations that they are supporting, just as an example. The New Israel Fund. There are a lot of groups like that. Alliance for Global Justice, I can go on. These organizations work not just in the US, they work in Israel and the Palestinian territories in Europe. So we can all point them out. We can all send letters to you know, the tax authorities, hearings in Congress, write in the press, you know, bring to the attention of this administration and all different bodies. We have a lot of more examples. There's a new policy regarding academical boycotts. So this would provide new tools for you guys fighting, but also in Europe, not just in the US, because it goes way beyond the borders of the United States because of the position of the United States. So there's a lot that we can do in in being active in all these fronts. Okay, I'll stop now. I just want to say one thing. We do work in cooperation, but it's not enough. We all have our strength. We all know each other's weaknesses, but we have connections that we can offer with governments, with experts, with the security organizations around the world. If you need ideas, if you need context, if you need a door to be open for you, please reach out. It's not so hard to find us. We're well connected to each other. We're happy to help. That's what we wake up in the morning to do. Hamas, they wake up in the morning to try to kill Jews. We wake up in the morning, try to advance our nation and work for a better future for all of us. So please use that. We're here for each other. We're here for you. And again, Richard, thank you so much. This was great. Thank you, all my colleagues.
Thank you all very much. I will sum up with just these words. We are all committed to something that needs to become more than just a passion, must become a determination, and that is justice and accountability. Thank you all.